Good afternoon. Welcome to our live Q&A on family law. Today we have a few interesting questions. The first question relates to relocation. The second question, variation of maintenance orders. And the third question regarding divorce, a foreign divorce. What happens if you want to get divorced in South Africa, however your marriage took place overseas? Those graphics below will explain to you how to connect to this webinar. You're welcome to do so. I'll be keeping my eye on the Advocate Abduroaf Facebook page. Should you pose any live questions, however, you're welcome to join me via Zoom as well. Question number 1, relocation with a minor child to the UK. I note that the courts look at what is best for the minor child when it comes to relocation. Can a parent who does not have primary care but has visitation in terms of a court order relocate to the UK? Is it possible to approach a court for consent? The person is not mentioning this, but basically what's being asked here is if the court order allows you reasonable contact, for example, contact with a minor child every second weekend of school holidays, but the minor child lives with one parent as a primary residence. For example, during the week, that parent attends to the schoolwork, the homework, and whatever the child requires during the week, and the other parent sees the minor child for 4 nights per month and half the school holidays. The question is, can the parent who is exercising visitation rights, the parent who has a minor child 4 nights per month, can he or she relocate with his minor child overseas, although the court order only allows him or her reasonable contact? So the bottom line, the question is, can a secondary caregiver, not a primary caregiver, relocate with a minor child overseas? The quick answer would be yes, it is possible. It depends on the facts of the case. Each case is different. For example, let's say the minor child is 17 years old, and now the minor child would like to finalize his or her schooling in the UK. There's a good schooling available, there's a good school available, everything is looking good that side of the world, and there's a good relationship between the parent who is relocating and the minor child, and the minor child is old enough to decide what is best for him or her because he or she is turning 18 years old in the next few weeks' time. Under those circumstances, if you look at the facts of the matter, it might be easy for the court to consent for the minor child to relocate with the other parent to the UK for a better life for the minor child. But let's deal with a scenario, a more complicated scenario, should the minor child be, let's say, 10 years old. Here the minor child is in the primary care of the mother. I'm using the stereotype example. And the mother is the one who attends to the school, homework, should the minor child be ill. The mother is the one who taught the minor child how to walk, how to potty, how to speak, and so on. So all those things are applicable here. Now the one parent wants to relocate to the UK for better life for him, and he or she, sorry, in this scenario, he believes it would be best for the minor child to relocate with him because it will be a better life for him and the minor child there. Whatever the factual reasons are, but that's what he is arguing. The question is, what would a court of law do? What would the court say? Is it possible for the court to say that the minor child can relocate? For a question like that, should someone like that come to my office, and it happens, come to my office with such a question, there are 2 hurdles which the parent will first have to um, jump over, for lack of a better way of dealing with this question, to overcome. The first would be, can he care for the minor child? That's question number 1. Can he attend to the minor child's upbringing, schooling, day-to-day needs, etc.? Is that possible? That's the first thing we have to look at. If he cannot jump that hurdle, then we cannot go further. We cannot deal with the relocation, because even if he proves that the minor child will have a better life, there are nannies there, there's a better education, better hospital facilities, everything is better in the UK compared to where the minor child is living in South Africa. And I'm using a very rude example, but let's say the minor child is living in a very not so developed township in South Africa. And here this parent wants to take this minor child to a different country, and factually, it is a better situation, better circumstances, better scenarios, and so on. The first question is, would that parent be able to care for the minor child? Can that parent attend to the minor child's homework, schooling? Is there a relationship between the minor child and that parent? What if the minor child falls ill tomorrow? Does this parent have the knowledge to deal with this minor child? Should the minor child be lonely, be sad, be depressed, and so on? Can this parent deal with that? So that's the first question we have to deal with. The second question would be, what would be the effect of the minor child relocating? The minor child is attending school in South Africa, his family is here, his maybe possible step siblings, and so on. That is a very important facet to look at. And I would presume, for the purposes of this example, that the facilities, the educational facilities in South Africa is not as good as the UK, for this example. Now, should we have now determined that it would be best for the minor child, no, sorry, should we now determine that this parent can care for the minor child, has the capabilities, has the temperament, has the necessary knowledge and skills to care for a minor child, then we can deal with the second leg as to whether or not it would be in the minor child's best interest to relocate and leave South Africa and live in a different country, and at the same time no longer have regular contact with the minor child's current primary caregiver. Now, what effects would that have on the minor child, psychologically, emotionally? The minor child might have grandparents here in South Africa, aunts, uncles, cousins, as I mentioned earlier on, step siblings, and so on. So those are the things which we have to now look at, because now we determine that this parent can potentially care for the minor child that side. Now, my guess will be as good as yours for this fictitious scenario. My apologies for that. However, if we cannot prove, number one, firstly, that you can care for the minor child, and that psychologically, emotionally, the minor child's well-being will be cared for on the other side, then you should not bother with such an application, because ultimately it's better to leave the minor child in the current situation where the minor child is, and should the minor child become a bit older, or when the minor child becomes a bit older, then under those circumstances you can relook the specific issue. So the answer to the specific question is yes, it is possible. However, it depends on a variety of factors, but ultimately, what is in the minor child's best interest? So that was the first question. I hope I gave some clarity on that specific topic. Question number 2, variation of maintenance orders. My ex-wife inherited a huge sum of money and 4 homes. She is still unemployed but is very rich at present. Are those grounds for me to approach the maintenance court for a reduction? I do not own a home and I am a salary earner. Typical scenario whereby one parent inherited or acquired a great sum of money and wealth, and the circumstances that were applicable at the time when the maintenance order was made is no longer the same. For argument's sake, let's say the father at the time of the maintenance order being granted, he earned a salary of 5,000 rand per month, and the mother earned a salary of 5,000 rand per month, and the court came to a judgment or decision, basically, that he should pay 1,000 rand maintenance towards a minor child. So under those circumstances, it was fair. We looked at the parents' income, because the mother would ultimately also have to in some way contribute also 1,000 rand, whatever way that is. But had the court at that specific time have known, or the facts were different, whereby the mother owned 4 homes, let's say those homes are worth 1 million rand each, now she has 4 million rand worth of assets. Should she rent out those homes, each home she might, for argument's sake, get 10,000 rand per month per home. There she pulls in 40,000 rand per month. She also inherited money, a huge sum of money. Her financial circumstances are obviously different to that of the father. So had those facts been in front of the court at the specific time, where the father earned 5,000 rand per month, but the mother is worth 4 million rand and pulling in rental income of 40,000 rand per month, would the court still have made an order that the father should pay 50% of the minor child's maintenance? No, the court would not have made such an order. The court would have made a total different order. The court might have said, you know, father, considering your circumstances, you should only pay 20% of the minor child's expenditure, and the mother should pay the balance, the 1,800 rand per month. Therefore, to answer your specific question, yes, it is something to consider, and it's worth your while to approach a maintenance court for variation of the order. A maintenance order is not there to be indefinite. If circumstances changes for any party, the party claiming the maintenance, for example in this scenario the ex-wife, the mother, or the parent paying the maintenance, in our scenario the father, if either of these circumstances changes, gets better or worse, you are allowed to approach a maintenance court for a relook of the facts so that a fair amount of maintenance can be paid. And at the same time, more importantly, should there be a change in circumstances regarding the minor child. For example, let's say the minor child was 2 years old when the order was granted. Now the minor child is 6 years old, attending school, extramural activities, school uniforms. The maintenance that was applicable when the child was 2 years old did not consider daycare, etc. Now the child is much older. Automatically the child expenditure has increased. It also calls for a relook of the maintenance order. I hope you understand that. So circumstances changing regarding the parents or the minor child, it allows you to approach a maintenance court for a relook. And the third question, the last question: what happens if I want to divorce my spouse in South Africa, but we got married in Japan? Must we go to Japan to get divorced? A question or a scenario which I'm dealing with quite often these days with international divorces. Now, in order for South African courts to divorce anyone, number one is you must be married. So firstly, it must be a valid civil marriage in that specific country. It should have been a valid marriage. And secondly, the party should either be domiciled here or resident here. There are some technical durations for residency. I'm not dealing with that now. But the party should basically be living in a province in South Africa. So let's deal with a scenario where the High Court would like to divorce you. So as long as one of the parents or one of the parties to the marriage lives in a province in South Africa, that specific court has jurisdiction to deal with the divorce. So if you are the plaintiff, you're the wife for argument's sake, and you live in Cape Town, and your husband lives in Johannesburg for quite some time, and you have been living in Cape Town for quite some time, and the marriage took place in Japan but 5 years ago, but it was a valid civil marriage, the Cape Town court can divorce you, or the court in Johannesburg where the husband resides. So that is also possible. So the quick answer would be, it does not matter where you got married, a local court in South Africa can divorce you as long as you are basically living in that specific area of jurisdiction. Those are the 3 questions. I see no live questions on Facebook Live. Thank you very much for joining this webinar, and I hope to see you online soon.